Hello, my name is Schlapper and this is my presentation on the reform of leases and the term certain rule. The topic I will be presenting on is leases, and in particular how the term certain rule should be revised. The case of Street and Mountford defines the three requirements of a lease. First, there must be exclusive possession. Second, there must be payment of rent. And third, there must be a term certain. This is the last of the three requirements that I will focus on. The term certain rule embodies the policy that a lease cannot run in perpetuity and that it must have an end. This rule has been extrapolated to include instances where the term of a lease is defined by the happening of an event. For instance, a lease which expires when the council widens the road which the property is situated upon. Furthermore, it has also been interpreted to apply to periodic tenancies which include a fetter of the landlord's right to determine the end of a lease. Such leases are held ineffectual because they violate the term certain rule, that the term of the lease could run in perpetuity if the specified event does not occur. This can be seen in the leading case of Prudential Assurance Co. Limited and LRB. In Prudential LCC, the predecessor to LRB bought the freehold of the strip of the land in front of the tenant's shop and leased it back to the tenant until it was needed for road widening. The road was never widened, however, LRB wished to end the tenant's use of the land. Prudential, the tenant, argued that as the road widening never occurred, the lease was not validly terminated. The House of Lords disagreed, finding that the lease was not valid, but there was an implied periodic tenancy terminable on 6 months' notice due to the continued possession and payment of rent. The justification for the rule is, however, debatable. Lord Templeman, who gave the leading judgment, provided no rationale for the term certain rule, other than stating that it had received 500 years of judicial acceptance. There are doctrines indicating possible justifications, however none are satisfactory. Lord Templeman noted that the lease could have been saved had there been a definite end date. This implies that the crux of the reservation is one concerning perpetuity, for without a definite end date the lease may never end. However, this reservation misses the point about the rule against perpetuities. This rule sanctifies the notion that it is offensive that property should be rendered inalienable for extended periods of time. However, a theoretically perpetual lease still has value, for it can be mortgaged and sublet. Another issue is that the distinction between a lease and a freehold could become blurred. This is not fatal, however, as the distinction already suffers from uncertainty in terms of permanence, relative ownership and exigibity. Addressing each in turn, both estates are capable of being permanent, for it is common to have 99 or even 999-year leases. In this respect, it is quite common for a lease to resemble a freehold. In terms of use, a tenant could stay in a property longer under a lease than a freehold. Therefore, to the outside world, the tenant in a 999-year lease is as good as the freehold owner. However, both estates confer the same relative ownership. It is wrong to define a fee simply by reference to unconditional ownership because historically, the Crown owns the land, and in both instances, the occupier is only entitled to use their land subject to external restrictions imposed upon them. For example, a freehold owner has to comply with the environmental regulations and cannot interfere with the free enjoyment of a neighbour's land for fear of being sued under the tort of nuisance. There is a preconception that the tenant's autonomy is more limited than the owner of a freehold. However, this is a question of degree, and this is variable dependent upon the leasehold contract and the area in which the freehold is situated. This leasehold contract could be drafted to closely resemble the powers conferred to the owner of a freehold, and the regulations in a specific area could be more onerous than a leasehold in another area. Therefore, a freehold and a leasehold should not be differentiated by relative ownership. Furthermore, both are legal estates capable of binding third parties. This is stated in Section 1 of the Law of Property Act 1925. Therefore, the exigibity of both estates are equivocal and cannot be differentiated on that front, or indeed any other front. The distinction is already blurred and should not be a reason to assert that a leasehold should not run in perpetuity. A further point is that a lease is fundamentally a contract, and therefore should be treated as a contract. using modern contractual jurisprudence. This sentiment has been advanced by the judiciary in other cases concerning leases. Lord Bridge in Hammersmith and Fulham, London Borough Council and Monk stated, "I see no reason why the question should receive any different answer in the context of the contractual relationship of landlord and tenant than that which it would receive in any other contractual context." Lord Bridge's point was that a lease was merely a type of contract and should be viewed jurisprudentially as such. Therefore, prudential appears to contradict modern contractual jurisprudence, which values sanctity of contract. I agree with Lord Bridge's analysis of a lease. Ultimately, leases are a product of defined transactional behaviour, which should develop in line with what the parties actually agreed, and not in line with the manipulation of abstract entitlements. Chitty states that the current result of the decision is that it penalises careless drafting, which is incoherent with the approach the court takes to carelessly drafted contracts. Moreover, there is empirical evidence suggesting that the court does not permit one to rely upon traditional proprietary principles to depart from what autonomous parties agreed upon. This approach can be seen in National Carriers Limited and Penalpia Northern Limited, where the doctrine of frustration was held not to frustrate the contract despite the fact that the lease of the warehouse had little use. Moreover, in Hammersmith and Fulham, London Borough Council and Monk, the courts favoured a contractual approach as opposed to a proprietary approach to determine how a lease had to be renewed. I submit that the same approach should be taken with the term certain rule. This approach would simplify the current law. Lord Templeman in Prudential found that implied periodic tenancies satisfy the term certain rule by construing the leases as a series of definitive leases. It is not clear why this does not offend the term certain rule, as it did in the case of Say and Smith. The court applied the term certain rule rigorously, without properly justifying it, and consequently had to create an inconsistency in order to reach a just outcome. The most obvious solution would be to accept that the term certain rule is no longer a required component of a lease. A more unusual development can be seen in Beresford and Mexfield Housing Cooperative Limited. This is another example of the court using unusual techniques to avoid the ambit of an archaic rule. It is important to note that Prudential was not overruled in Mexfield. Although the result in the case is correct, the reasoning defies legal logic. It is suggested that an uncertain term is converted into a 90-year lease for life through the application of Section 149 of the Law of Property Act 1925. It is not clear if Section 149 was intended to cover uncertain terms, but even if one overlooks why this would happen, one is still left with questions as to how they possibly bind third parties and how they can be validly created. There are several problems with this decision which cause confusion. First, it is not clear what the ambit of the term certain rule is. There are two interpretations of this case, and the judiciary did not clarify which way the lease should be viewed. It could either be viewed as a simple lease for an uncertain term or a periodic tenancy with a fetter on the landlord's right to determine the end of the lease. Secondly, the mechanics of the Mexfield lease have not been clarified. An example would be the mechanics through which the tenant would pay rent. The 90-year lease appears to fall under Sections 166 Commonhold and Leasehold Reform Act 2002. This section states that the payment of rent is not payable unless notice in the prescribed statutory form has been served. Whether written notice is required for the Mexfield lease is uncertain. Thirdly, the Mexfield lease is a long lease under the Law of Property Act 1925. Therefore, it appears that it has to be registered for a tenant to have legal title. Finally, it is unclear whether the statutory implied repair covenants will apply under Section 11 of the Landlord and Tenant Act 1985. This gap exemplifies the need for reform. Reform would not affect long-established titles more than the current position, and the ramifications in keeping parties bound by their agreements should not be overstated. Firstly, the impact of reversal will not affect large numbers of leases, as proper drafting would mean that there is a term certain. The majority of leases are drafted by qualified and trained solicitors who are more than aware of the term certain rule. Therefore, in the vast majority of leases, there will be a definitive end date. It is no coincidence that only 2 cases on this subject in recent years have reached the upper echelons of the English legal system. Therefore, reform would not have a dramatic effect on the nation's leaseholds. Secondly, under the lease agreements, risks are allocated accordingly, meaning there is no injustice in keeping parties to their agreements. A lease is a bilateral agreement, and therefore it is within the power of the tenant to refuse to accept an agreement where the lease does not have a term certain. This is, however, predicated on the assumption that the lease necessarily benefits the landlord. This might not be the case, as indeed this was not the case in Mexfield. The landlord also agrees to the lease and does so knowing the risk. It is therefore open to both parties to negotiate and reach a mutually agreeable solution and have an uncertain term. Thirdly, the current position affects long-established titles, more so because it allows landlords to circumvent the fetter of the right to determine the lease. The flip side to the argument is that not reforming the law could affect existing leasehold agreements, as the law prevents certain contractual arrangements which have been freely agreed. This argument was used by Lowe when he said that the term certain rule should be reformed as it frequently denies efficacy to perfectly sensible commercial arrangements. Therefore, the allocation of risks will be undermined, and this defies the rule of law. Parties are fully entitled to plan their lives and rely upon the legal arrangements that they freely enter into. Ultimately, it is logical to reverse prudential, as no satisfactory rationale has been advanced and the current position is inconsistent with both land and contract law. The rights arising from a lease should be dictated by the agreement of the parties and not the manipulation of archaic proprietary principles. This brings the presentation to an end, and I hope it has served its purpose. Thank you for watching.